I'll get started then. Basically, those that tuned into our last module probably have an idea about the general right to education and the importance of that and how international law and domestic law protects that right in New Zealand for all children between the ages of 5 and 19. This particular module is going to talk about when schools are empowered to discipline students and the limited circumstances in which they can do that legally under the Education Act. So just to get started, if anyone has any problems, again, use the chat box. Feel free to use the chat box for any questions that might come up during the slides, and I'll be leaving the chat box open for a few minutes after the webinar as well in case there are any other follow-up questions that people want to ask. So feel free, and also we'll have some contact details at the end, so if you want to email me, that's also possible. Cool. So talking about Section 13 of the Education Act is the key section I kind of want to draw your attention to when we're talking about the right to discipline students and remove them from school. Section 13 of the Education Act is a purpose section which sets out how you deal with students under Section 14 of the Education Act. So that it sets out that there's a requirement that schools consider a range of responses depending on how serious the misconduct of the student is, and that any action taken by the school should minimise disruption to the student's attendance, should help facilitate a return to school, and any action taken should also be consistent with the principles of natural justice. Natural justice is a legal concept, so I will go into a bit more detail in the just outlining what natural justice would entail, but it is quite an important concept which is central to any sort of discipline that takes place under Section 14 of the Education Act. Crucially, what you'll note about Section 13 is the fact that really discipline and removal of a student from school should be a last resort. So it should never be the first instinct of a school just to seek to remove a student. It should always be the last resort, and it should always follow due process set out under Section 14 before the school can justify their actions. So the purpose section is really clear about that. So if you ever are working with a young person and you're sort of trying to advocate for their right to stay in school, Section 13 is a really key section in terms of the purpose of education and the purpose of the Education Act and how schools should be using the disciplines sections under Section 14. So Section 14 of the Education Act is your key section. This is the section that gives the schools the power to remove a student from school, and it's only in very limited circumstances. So generally you'd expect if a school was going to take action to remove a student from school, they would have to do so in compliance with Section 14, and they would only be able to do that if it was justified and it met the Section 14. So, Section 14 sets out that a principal of a school can stand down or suspend a student if the principal is satisfied on reasonable grounds. So there's a few bits in there that I kind of want to break down. Firstly, stand down is the temporary stand down of a student from school. And I'll talk about that in a little bit more detail later, but essentially it's temporary removal of a student from school to let them think about what they've done, essentially. Suspending a student is a little bit more serious. It means that not only are they removed from school, but they will face a board hearing to determine their ongoing education at the school. So the principal needs to be satisfied on reasonable grounds. Reasonable grounds is quite a key concept in there. It's a legal concept. The principal needs to be reasonably satisfied that there is enough to justify removal from school. So it can't just be a hunch, and it can't just be that they've taken a dislike to the student. There must be reasonable grounds. And if the case ever goes to court where it is challenged, the principal would have to be able to show that they had reasonable grounds to take that serious step. So going back to Section 13 of the Education Act, remember that the whole purpose of the section is to minimise disruption to a student's education in school and find the best possible outcome that's going to achieve their continued education. So obviously it must be on reasonable grounds. So the first ground on which a principal can take that step would be A, gross misconduct. So what is gross misconduct? It's quite a technical term. There is a very little definition of what gross misconduct means. If you look in Ministry of Education guidelines, they refer to the 1 or 2 court cases in the High Court where this has been considered. The High Court has in one case said that they would consider that gross misconduct would be gross and reprehensible conduct to a serious degree, a one-off incident justifying that sort of response. So again, not something that's merely trivial, but something quite serious. The second ground on which a principal could take action would be if something was continual disobedience. So continual disobedience has also been discussed in policy that the Ministry of Education has released, guidelines, and also in case law, and it would be expected that continual disobedience is quite serious. An established pattern of misconduct and willful nature on the part of the student aimed at being continually disobedient. So what's crucial about that is you can't just point to one incident, or you can't try and link one incident that's very far-spaced in time from another incident. There should be an established pattern of misbehaviour, and it should be an established pattern of willful misbehaviour which is serious enough to justify removal from school. So again, going back to that Section 13 requirement, be serious enough to interrupt education and disrupt their continued schooling. There is a secondary requirement within each of those sections. So under Section 14A and B, and not only do you have to show it's either gross misconduct or continual disobedience, so it's serious enough that it meets the definition, but a secondary element that is required to be proved is that it must also constitute a harmful or dangerous example to other students at the school. So, for instance, if you have a gross misconduct situation where the student punches a wall, causes substantial damage to the wall, but there were no students around to witness it, and no one saw it, there's a question of whether it's a harmful or dangerous example to other students at the school. The flip side is the school would probably argue, well, the students would see that someone had done that to the fence, therefore it does constitute a harmful and dangerous example. But it is important that both elements are fulfilled before the principal would be justified in coming to the conclusion that the student was responsible for gross misconduct or continual disobedience, justifying stand down or suspension. So the evidential threshold is obviously not a criminal justice evidential threshold, so it's not beyond reasonable doubt, but it is reasonable grounds and reasonable evidence. So I'll talk a bit more in the later slides about what that means and what that means for a fair investigation, but essentially it can't just be a hunch, so the principal can't have a hunch, I think this kid's bad, therefore I'm going to exclude them from school and suspend them. The third ground, which is not used that often, but is still important and has become increasingly important in recent times, is the third ground that it's likely that others will be harmed or that the student poses a serious risk to safety of other students and staff at the school. It used to be that this was very rarely invoked by schools, the reason being it generally required an immediate threat to safety and requiring immediate removal, and that there were just simply no other steps that could be taken. So it's not that often that that would have come up, but we are seeing this come up increasingly more and more in respect to special needs students. So this has been cited by schools as a response to special needs students when they have had behaviours exhibited that are indicative of their special needs. Sometimes if things have escalated, schools have said, right, we're removing you under Section 14 under that section. I guess what I'd say about that section is it's quite hard to justify that because you need to be able to show an absolute immediate threat that can't be dispelled by any other action whatsoever. And generally what usually happens with situations with that is there are de-escalation plans for special needs students and other things, so it would have to be quite an extreme set of circumstances to hold up to challenge in court or otherwise. So in addition to the sort of bare outline that there is under Section 14 of the Education Act, there are also guidelines that are published by the Ministry of Education. So the Ministry of Education has published guidelines around stand-down suspensions and exclusions. These are primarily directed towards principals and boards of trustees, and it sets out legal options and duties for them. It's a really thick document, so if you do get the chance to have a bit of a read in more detail, it's got a lot more detail about what the Ministry sees as being fair and reasonable in a process like that. But some of the key requirements that it does set out are things such as being fair and flexible, adopting a proper process, and ensuring natural justice and due process is adhered to. So I will talk about this in a bit more detail in the further slides, but essentially you can't just make a decision and decide that a young person is guilty of the gross misconduct or continual disobedience without having being able to show that you've conducted a fair investigation, you've considered all evidence, and that you've weighed all that evidence before you've come to a conclusion and you've properly documented it. Very much almost like a criminal justice sort of investigation, but obviously the threshold is not going to be as high as beyond reasonable doubt. But yeah, a copy of those guidelines are available on the Ministry of Education website and really helpful if you're ever advocating or supporting a young person in a situation where they're facing discipline with their school. Those are helpful in terms of guiding whether or not the school's followed an appropriate process in undertaking discipline. So what is being fair? The ministry guidelines sort of talk about the fact that being fair includes treating people with respect, taking account of their culture and their own individual abilities, and the key thing is communication. So keeping parents and students informed about what is happening, how things are being investigated, and what is at stake. So the consequences are you will be facing, for instance, a board meeting, and this could mean removal from school. So following the rules, so not only following Section 14 of the Education Act, thinking about all the requirements under Section 13 to minimise disruption and retain in education where possible, following those rules and ensuring that you make sure that the student and the parents have a fair go in the process, essentially. So you're not just making a decision and carrying it out without giving them the chance to be informed and have input into the situation. The Ministry of Guidelines talk about what being flexible is as well. So that involves considering all options. So if the school has a number of options in front of them, which would include, for instance, let's just say little Johnny has been in a violent altercation with another student. The school has a number of options. They could send Johnny to anger management, ask him to undertake counselling, ask him to write an apology letter. They could ask him to stay away from school a little bit longer for an extra week, extend the suspension, or they could just seek to exclude him altogether. And if they don't weigh all those options and weigh which is best in the circumstances, then that's not being fair and flexible in accordance with the Ministry of Education guidelines. What is to make sure that whatever response they adopt is proportionate to the crime depending on the circumstances. So obviously a student that trips up another student and then faces permanent removal compared to a student that has violently assaulted another student and faces permanent removal, that's all relevant sort of consideration. The important thing is that all circumstances need to be considered and that all factors need to be looked at before a decision is made. The key thing is that the principal has the first port of call of investigation in these circumstances. So when a student is alleged to have misbehaved, usually what happens is the teacher or deputy principal might get involved. There'll be an investigation. The principal needs to make their own investigation and do it. So interview all the relevant people, gather all the relevant evidence, consider all the evidence before making a decision whether or not it meets the definition or requirements of gross misconduct or continual disobedience. From then, the principal then needs to make a decision about whether it warrants just some sort of internal discipline, which doesn't involve formal discipline under Section 14, or whether it involves is serious enough to warrant Section 14 involvement, which might include stand down. So stand down being that temporary removal I talked about. With stand-downs, it can only be a maximum of 5 consecutive days and a maximum of 10 total school days per term, and that needs to be notified to the Ministry of Education, or the principal can take the more serious step of suspending the student and saying, well, actually, I think the Board of Trustees needs to see the student and consider what the student's future is at the school. So they'll be suspended for 7 days. A board meeting must be held within 7 days to determine the student's future. So a lot more serious. There are also options where the principal might decide that it doesn't warrant formal intervention under Section 14 for a stand-down or suspension, and might give them a lunchtime detention or something like that. But the key thing is the principal shouldn't ever be removing a student from school without following these proper processes. Otherwise, if the principals could just send them home without properly following these processes, there would be no monitoring or protection of the student's rights to stay in school, and that's particularly important in light of Section 13 of the Education Act. So natural justice. I talked about the fact that natural justice is a big part of Section 13 and all decisions and things that are done under Section. So what is natural justice? It's a concept that informs all of law. It's not just in the Section 14 context. It's part of all criminal law. It's part of civil law, and it requires basically being treated fairly and being given a fair go. So you shouldn't ever be expected, and I don't know if you've ever heard of the novel Crime and Punishment, but the idea being that someone should never have suddenly be hauled out of their house and brought before a criminal tribunal, not knowing what the charges are against them, not knowing what the evidence is, and found guilty without a chance to respond. It's the same sort of thing. Natural justice requires a person being given adequate notice of the allegations against them, giving them a chance to be heard and respond to those allegations and have the responses considered, having a decision maker that's unbiased. So you don't really want a principal who's had it in for a kid all the time and is looking for evidence to find this kid responsible for gross misconduct. Same with perhaps a bias board. You want the decision maker to make a decision based on facts, and take into account your individual circumstances. So obviously, if you've got a child that has a particular physical disability which causes his arm to twitch, and that caused him to twitch and hit another student, you would want that to be taken into consideration under individual circumstances. And crucially, it should be important that any decision that is made should be recorded to explain how the decision was made, so that you can actually follow through the reasoning of the decision maker and see whether there's any grounds on which you don't agree on. So these are the rules I was talking about that sort of inform Section 14. These are the bylaws. These rules sort of set out what happens when you go through the Section 14 process. So they set things out in a lot more detail, and they're also informed by the Ministry of Education guidelines which have been published, which tell schools how to go about this process fairly. Key sort of rule there, Rule 7, sets out the principles that apply to processes, practices and procedures. And just for example, it talks about things like being guided by the charter of the school, maintaining a safe learning environment and respecting cultural diversity. So really sort of straightforward, common sense things that you would expect that should guide the process. The Ministry of Education guidelines also talk about how it would be appropriate for a school to investigate to ensure that it was consistent with natural justice and it was flexible and fair. So they talk about the fact that acting fairly could sometimes mean involving a parent or a suitable adult as part of the interview process or in consultation if required. You'd expect it would be sort of like criminal justice in the sense that you'd be able to put the allegations to the student and ask for their comment and response, and you obviously should do that in a culturally and appropriately sensitive way. So obviously not pulling them out of class in the middle of class in front of everyone, and giving them the chance to consult a parent or a suitable adult if it's appropriate in the circumstances. Principals should also be thorough, so they shouldn't just take the word of, say, one student who's had a particular grudge against another student. They should be thorough and investigate all possible sources of evidence and all major disputes or uncertainties. for instance, if the student was actually seen doing this bad act, or if this was only reported to them and it's hearsay, they probably need to do a lot more investigating before they can confirm that is the case and take the serious step of making the finding that they're responsible for gross misconduct. And all steps through the investigation process should be documented, so there should be records of what's actually happened, how that's been investigated, and how it was fairly assessed. So how does the principal decide? Basically, the principal needs to be satisfied on reasonable grounds that it meets the threshold for gross misconduct or continual disobedience. So quite serious, remember, I talked a bit before in the earlier slides about the definition and it being quite serious. And likewise, when I talked about the harm and safety possibility of excluding a student, it needs to be shown that it's likely that others will be harmed. This all needs to be considered in light of the individual circumstances of the student. Section 13 of the Education Act, the purpose section, is really clear. It should be an individual response to an individual student, and it should be appropriate for that student. And the key guiding consideration in light of Section 13 and the importance put on retention and education is needing to determine whether or not this conduct is significantly blameworthy and it actually justifies removal of the student from school, even though it might damage their education and long-term prospects. And you'll all be quite clear about the long-term effects of removal from education. So it is quite a really serious step. And for that serious step, it should really go through a fair, measured, reasoned and carefully investigated process. So yeah, as I said before, gross misconduct is not trivial. It's got a really high threshold and it needs to be fact-specific. So you can't generalise. You can't sort of say, well, the school rules say that if you bring drugs to school, it's automatically gross misconduct, because it's going to differ from every case to case. And obviously sometimes you might have really extenuating circumstances, so you want to look at the individual circumstances of the student. For instance, the student is being peer pressured and bullied and has brought a bag of herbs to school and has passed them off as marijuana. That may not be as culpable or blameworthy as another situation. The High Court case, as I said before, has said it's striking and reprehensible, and it must be a harmful or dangerous example. The same thing with continual disobedience. It needs to be an entrenched pattern of behaviour, and again, that secondary element is really important. It needs to be a harmful or dangerous example in each of those cases of cited misbehaviour. And you really need to think, in other words, if this was to go unpunished, would it undermine discipline and safety standards? And that should be the litmus test for the principal, no other tests. Not this student is a troublemaker, not that we have school rules or anything like that. It shouldn't be general. It needs to be very specific and considered in the individual circumstances. As I said, the serious harm exception happens to be called upon sometimes, but it's not very often. And it should really be a last resort response to safety concerns. And if the principal can manage the risk in other ways, they must always try those other methods first. And it should be an immediate risk of distress and injury. So decision making by the principal, if there is limited information within the school, good practice or fairness would probably dictate that they should consult with the parent or other relevant adults if necessary. And if they consult, they may actually find out more about the incident, so it might actually raise pastoral concerns or mitigating factors or out-of-character behaviour, past trouble, or if guidance or counselling might be needed, or if things are happening in the young person's life. So, for instance, are they going through a family divorce? Has there been a death in the family? There could be a number of factors which affect this, and if the principal doesn't do thorough investigation and check all those things, they won't have actually gathered enough information to make it an informed decision about what the appropriate response is in the circumstances. So you remember I talked about the stand down, the temporary removal of the school under formal provision under Section 14. It's the lesser of the more serious responses under Section 14 that the principal can take, which is formal and notified to the ministry. So the stand down will start one day after the decision. So if the student can't be sent home, they can be supervised until then. And as I said, there are strict time limits around this. It can't be more than 5 school days a term and a total of 10 school days per year. So if they have exceeded that, they're either doing it informally and not legally through the Section 14 processes, or it's in breach of Section 14. So that's, if you're ever supporting a young person that's in that situation, they've obviously got legal grounds to challenge it, because it would be in breach of Section 14 of the Education Act and in breach of Section 3 of the Education Act, which we talked about in the first module about guaranteeing the right to education. So parents need to be advised if a student's been stood down formally, and the ministry is also advised. The key thing about stand down is it is only a temporary removal, so the student remains on the roll during that time, and it's only possible for the principal to remove the student if they are enrolled in another school or if the student decides to leave school at the age of 16. With the stand down, parents can request a meeting with the principal to discuss it, to try and work out, what went wrong or how this could be avoided in future. And the principal does have the ability to lift the stand down a bit earlier. And again, throughout this whole process, the principal has an obligation, if necessary, to provide guidance and counselling to the student under Section, I think it's 70 odd of the Education Act. Suspension. So this is the more serious step. So the principal's decided that it's more serious than warrants temporary removal or stand down, and that the student should be suspended, and that they should come before the board to determine their continued future at the school. Parents need to be advised, and the Ministry of Education guidelines are pretty clear that ideally this should be in writing. A good letter advising them what's happened, and advising them about the timelines around what's going to happen with the board meeting and all the rest. Student remains on the roll. They can't be removed from the roll until a formal decision is made by the board to remove them from the roll, and I'll talk a little bit more about that in future, but there is a really strict timeline and process around that, so schools can't just remove students from the roll, which could be important if you're ever supporting a young person in that situation. There's a requirement under the Education Act that the principal ensures that guidance and counselling is made available to a student that needs it through this process. And I refer again back to Section 13 and that purpose section where it requires the principal to minimise disruption to schooling. And the principal always has the ability and discretion to consider allowing the student to attend at school during suspension. And this could just be for things like counselling, so they get the support and help they need during this time. So a bit about the suspension process. It's really quite strict. So if it isn't followed, you do have grounds to challenge the procedure if you're supporting a young person. The principal needs to prepare a report detailing the misconduct for the Board of Trustees. It should be specific enough to lay out everything that the principal is relying on with times and dates, and just background information to the student as well. The report has to be delivered at least 48 hours prior to the board meeting. Now remember I talked about the fact that within the suspension period of 7 days, the Board of Trustees meeting must be held within 7 days, otherwise the suspension potentially becomes invalid. So within those 7 days, the board meeting has to be held, and 48 hours prior to the board meeting, a report has to be delivered. So it's again going back to that natural justice, fairness type stuff. The student and their parents need to be made aware of the allegations against them before they can turn up to the Board of Trustees. The key thing is there should be no surprises, and hopefully the report should help identify any disagreements, and it should set out the background information, history and discipline history and any pastoral support that the student has had in the past. With the Board of Trustees meeting, the general rule is it should be held as soon as practicable. So obviously giving the student the least amount of disruption and least amount of time out of school as possible. The minimum time would be 48 hours notice, and this time can be reduced if all parties agree. Written notification of when and where the Board of Trustees meeting is going to occur should be given to parents, and it should also set out what options the Board of Trustees has open to it. When I talk about options, I'm talking about things like what's available under the Education Act. So the board may be able to allow the student to return to school, simply lift the suspension and let them return. They could lift the suspension with conditions, they could extend the suspension, or they could take the step of deciding that the student should be removed from school permanently. So all of that should be set out in the information which is given to the parents and the students, so they know exactly what's coming. Again, that no surprises, natural justice and fairness. So yeah, as I keep saying, natural justice is a really central concept that informs all of this. So if you ever sort of feel procedurally there's some issues with how a student has been dealt with, natural justice is probably the ground on which you want to rely on to support any challenge to that. So all complete information must be given to the parents, and as I said, the meeting must be held within that particular period of time. If they don't, then arguably the suspension is invalid. So you can see here that if it is at the end of term, it must be within the 10th calendar day, but that's not going to be that often. That's just going to be when it's the end of term. Otherwise, it's 7 days, and there's no, give or take around that. And the time starts ticking on the first school day after the decision to suspend is made. Key things about the Board of Trustees meeting. The Board of Trustees will have a constitution and a number of rules governing how they operate, so they must have a quorum to make that decision. So if they don't, it's potentially another ground to challenge the decision. The Board of Trustees has a very different function to the principal. So if you think about the principal kind of like the CEO of the company reporting to the board, the principal is responsible for the day-to-day running of the school and obviously has made a decision in their judgment on reasonable grounds that the student has met the threshold for gross misconduct or continual disobedience, which is quite serious. And they've said it's serious enough that I want you, the board, to look at it and consider if the student should remain at school or what their future at the school is going to be. Now, the Board of Trustees is not just simply there to accept the principal's recommendation and say, okay, let's remove the student from school. The Board of Trustees has an independent function set out under the Education Act to sort of act as a check or balance on the principal's decision. So they essentially need to reinvestigate and look at all the evidence put forward by the principal's report, reinvestigate and accept all the evidence that the student might wish to put forward, hear from everyone and consider everything before they determine whether or not, yes, the student has either met the threshold or no, they haven't, and then decide what the student's future will be. They need to consider all views and all options and take into account the student's individual circumstances before they make any sort of decision. The key thing is that the board can adjourn if they need a bit more sort of information and they need to gather something, but they need to make a decision before the applicable date, otherwise they're going to lose the power to, for instance, continue the suspension or remove the student. So as I said, those timeframes are really important. If you're supporting a student where those timeframes haven't been adhered to at all and they've been suspended for 3 weeks and there's been no Board of Trustees meeting, arguably that suspension is now invalid and they can't really then say, well, we're now going to remove the student permanently from school. So as I said, the Board of Trustees has a number of options available to them. They can choose to lift the suspension without any conditions. They can lift it with conditions. So one common example I can think of would be, for instance, a child who's been found dealing drugs or consuming drugs at school. They could lift the suspension, but say there are conditions that you need to undertake drug testing or that you need to undertake some sort of drug counselling course. And then see whether the student agrees to those conditions. I'll talk a little bit more about conditions in a second, but the thing about conditions is that they need to be fair and reasonable, so they've got to be something the student can actually comply with. So if you say that the student needs to then enrol in a particular course which is $3,000 for drug rehabilitation, that may not be within the student's means, ability, or physical capability to do, and so that probably wouldn't meet the definition of a reasonable condition which a student can comply with and that can be imposed by the board following removal. So yeah, the board can also extend the suspension for a reasonable period with conditions, and this should always be aimed at facilitating the return of the student. So you wouldn't expect that they would extend it for undue periods of time. Reasonable period is as little time as possible as is necessary to facilitate the student's return. Say, for instance, they need to go and attend an immediate rehab course or emergency rehab or something like that, or need to go see a doctor, then they may extend it for a short period, but obviously nothing long and ongoing. So I wouldn't expect that a student will be out of school weeks and months on end after that. And the most serious responses that the board can take can be exclusion, which is the label given where a student is under the age of 16 years old, or expulsion, where the student is over 16 years old. There is an important distinction between that, which I'll talk about in a bit more detail in future slides. So again, I'll come back to this conditions thing. They need to be reasonable. It should be aimed at facilitating return of the student to school. So is the condition aimed at the cause? So if you're sort of saying to a student, okay, you've been violent and you've assaulted another student and we've deemed that you're guilty of gross misconduct, we're going to lift the suspension with the condition you submit to drug testing. There's a really good argument that the drug testing is not at all related to the reason that the student has come before the board in the first place. So if you're ever supporting a student in that case, you would probably say, well, actually, I think that condition is unreasonable and it can't be complied with by the student because it's not related to the misconduct. It also needs to be a condition that's within the control of the student. So, for instance, think of a student that's continually late, and it's because mum has chronic fatigue syndrome, can't get out of bed in time to get the student to school, and then they are brought before the board for continual disobedience, for continually being truant at school. If they put a condition on the student saying that you will attend at school by 8 a.m. every day, it could be something that's out of the control of the student if they're reliant on mum to take them to school. So that's another example of an unreasonable condition, or a condition that's not within the control of the student that shouldn't be imposed. The Board of Trustees needs to take appropriate steps to facilitate the return of the student to school. If there is any extended suspension in place, it's always important that the student retains a right to education. As you remember, I talked about Section 13 and minimising disruption. The student should be monitored and written updates need to be provided. The board needs to appropriately document their decision and show the reasons for it in writing and how they applied the statutory criteria. Otherwise, they are open to challenge, and if they can't show that they've properly documented and considered everything, potentially that could be challenged in judicial review in the High Court or by the Ombudsman through complaint. So there is a crucial distinction between an exclusion and an expulsion. I really want to keep emphasising the whole thing about being a last resort. Under Section 13 of the Education Act, it's so clear it should be a last resort, permanent removal from school, and that all other options should be considered before that happens. So if you're acting for a student or supporting a student where other options haven't been considered, there's a good argument that they haven't complied with Section 13 of the Education Act. So exclusion is for those under 16, expulsion for those over 16, and these have real consequences once a student's over 16. So where a student is under 16, the principal has an obligation to arrange for the student to attend another school within 10 days. And if the student is out of zone, the Ministry of Education can endorse or direct enrolment of that student at another school. If a school refuses to enrol, the Ministry of Education can force them to enrol with a direction. The difference is once you're over 16, legally you can leave school, so the principal's obligations aren't really there as they would be when the child is under 16, and the Ministry of Education is far less likely to exercise powers to direct once the student is over 16 because legally they can leave school. The crucial thing is, and it's important if you're supporting any student in this process, is that the student should not be removed from the role until a new school has been found. So they shouldn't be drifting without any form of enrolment on with the school during that time. Although we have heard stories where students have been off off the roll for months on end. So really important if you are supporting a student to make sure that the principal complies with their obligations within 10 days, and the ministry supports that as well. So what do you do if the board decides to exclude or expel? You can ask the board to reconsider their decision. Also, if a student fails to comply with conditions that are imposed on suspension, a principal can ask that the Board of Trustees reconsider their decision as well. Reconsideration for this sort of thing should be held within 7 days of the request, or within 7 days if it's at the end of the term. This should all be properly documented, and again, all that natural justice stuff applies again. So there should never be any sort of inkling from the board that, okay, we've decided before this kid's a bad egg, we don't want to reconsider this, and refuse to even reconsider, for instance, if there's new information or a change of circumstances. What could have happened is a student might have been excluded, and they've now undertaken counselling, or counselling has now been undertaken to address the issues that caused the offending. For instance, someone who punched another student was really angry because that day he found out his parents were splitting up, has now undertaken counselling and is enrolled in a program. If that's the case, then what they can do is then ask the board their decision if there's no options for the student to attend another school that's suitable, and put forward the new information or change of circumstances with the student and ask them to reconsider. The problem with the reconsideration process, and it is a problem with the entire way that the Education Act is structured, is that it's essentially asking the same board who made this decision in the first place just to relook at their decision. So generally you would hope that if there's new information or change of circumstances that the board would want to reconsider their decision, but you are asking the same people to reconsider their decision again. So it does leave you with sort of limited circumstances if they're not at all interested, and they don't have to necessarily justify coming to the same conclusion if they've reconsidered the information and they still consider it's gross misconduct, and that is the most appropriate response. So really, once a child has been excluded or expelled, it's a really hard road for them in terms of continuing education, particularly where they're over 16. So what can you do when there is an adverse decision? There are a few options. Firstly, I talked about the reconsideration option, which is completely discretionary. It's for the board. So you might want to put forward a change of circumstances or new information. Obviously, you remember what I said about there being an unbiased decision maker. So obviously, if you've got an inkling that the board might have a conflict or they've got a bias against your particular student, you may wish to take it to the chair of the board or take it further, for instance, support the young person in notifying the Ministry of Education or otherwise. There's also the Ombudsman. So there is the potential where a student's been excluded or expelled to lodge a written complaint with the Ombudsman and ask them to investigate whether or not the process was fair. So for instance, if you think that the board didn't follow the principles of natural justice, they only heard one side of the story, were only interested in one lot of evidence, not the other, you could potentially write to the Ombudsman. The only problem with the Ombudsman is that he's quite overworked. He will issue a written recommendation, but it, on average, takes at least 2 months, and it's only a recommendation which the school can ignore. So they don't have to take account of it, and it's not binding on them. It's still very persuasive, so no school likes to have the Ombudsman tell them that they've done things wrong. So obviously, it can be quite helpful for a young person, but it actually doesn't really help the young person in the immediate future because they would have been out of school for 2 months by then, and the most important thing probably is to get them placed in a new education setting, and that is more likely to be achieved through liaising with the Ministry of Education and the principal of the school who can help with placement. And really they should be doing it within 10 days. So if they're not and you're supporting a young person in that situation, pressuring them and haranguing them and reminding them of those obligations is going to be very important for you. The third option that I've listed there is judicial review. It's really almost not really an option for most people because judicial review is action in the High Court, and it only allows you to challenge if the process So if they failed to properly document something, or failed to properly record things, or failed to properly apply natural justice, you could apply to the High Court to review the process. And the problem with that process is because you're not allowed to challenge whether or not it was a wrong decision of gross misconduct or continual disobedience, only whether or not the board followed a fair process, it means that there are very limited remedies. The court's not going to be able to order that the student immediately be re-enrolled in school. So again, judicial review, you're talking in the vicinity of $30,000 to $50,000 to get proceedings kicked off. And it can take up to 18 months to get a hearing in the High Court in Auckland. So it's really not a very viable option for most people, and it doesn't actually ensure return to education for most students in a nice, quick time frame. I put in there as well the HRC, the Human Rights Commission. This is really only relevant, for example, if you've got a special needs student with special educational needs and you think that the way that they've been treated and them being disciplined through the school as a result of their disability, and that's a discrimination issue. I will talk about this in a lot more detail when we do our special education module, because there's so much in here, and there's so much detail and so many other steps that can be taken, which we can talk about then. But just to flag it here in terms of an adverse decision, because the reconsideration and ombudsman options don't really have a lot of teeth in terms of immediate return of the student to school or overturning the decision. In the Human Rights Commission, if you've got a discrimination issue, and it might not just be special needs, there might be another discrimination issue. So things that spring to mind for me are things like disciplining a student where they're growing a beard for religious reasons, or they have a moko, a tattoo, and that's part of their cultural belief, and they've been discriminated against and discipline taken against them. Then the HRC might be a good option, because what you can do is request urgent mediation with the school, and you can support the young person through that process, and you may be able to negotiate an outcome which is better for the student rather than exclusion or removal from school. This is why Youth Law has consistently said we really think that there needs to be an extra layer of protection for students, because it's kind of the end of the road once you're removed from school. It's quite hard to get them replaced. They're removed from school, they're isolated from education, they fall behind, all these things happen, and there's a lot of flow-on effects with criminal justice, social welfare once you're removed from education. So we've consistently advocated for the establishment of an independent appeal tribunal. So students could appeal the decision. It would be cost-effective and free to access, and it would quickly consider whether or not the decision was right substantially and procedurally, and then could help students with quick resolution so they weren't deprived from education for such long periods. So if you are interested, there is a copy of our report, our law reform report, which we did investigating how we could set up an independent tribunal on our website, and it's called Out of Sight, Out of Mind, published in 2012. There is a summary on the website as well as the full report, so if anyone's interested, feel free to hop on the website and have a look at that. But hopefully this has given you a nice quick flyover of the disciplinary process that schools can undertake. And I guess I'm just going to give a quick overview of your quick take-home tips from the webinar. Schools really do need to justify any removal of a student from school, particularly a permanent removal, but any removal at all. So they shouldn't be removing students unless they're using the Section 14 provisions appropriately. And Section 14 has very clearly defined circumstances in which you can actually justify removing a student from school. So if you don't meet those thresholds, then arguably you should never be removing a student from school. What we do hear a lot more of is students being removed informally where they don't follow those processes, which is arguably illegal. And, when they're removed for long and extensive periods or permanently without going through any sort of process, it's what we would call an illegal or Kiwi suspension. So there's a little bit of information about that on our website as well, but definitely, if anyone's interested, there's also going to be a paper that we're publishing later this year about it. the key take-home tips that you need to remember when you're supporting a student is that natural justice is really important and informs everything, and Section 13 of the Education Act is very clear and central to all of this. There are procedural requirements. Schools need to properly document everything that they do, and there are strict time limits around what they do. So if they're not adhering to the 7-day having a board meeting and suspension, or they're standing kids down for more than the limited days, then what they're doing is in breach of the Education Act and unlawful. And always, any removal should be a last resort. Do feel free to call the 0800 number at Youth Law if you do have a case of a specific young person and they're needing advice or assistance. It is sort of a specialty area for youth law, so I'm very happy to help with any queries that you might have. And I'm just going to put up the last slide, which has got all our contact details on it again. So, sorry, I've gone the wrong way there. Yes, so there's our 0800 number, open between the hours of 10 and 4 Monday to Friday. We've got a downloadable app for smartphones, which is great for technology-savvy young people. We're on Facebook, and we're going to have the PowerPoints up for you, as well as the recording of this webinar if you want to watch it again. Obviously, it's been a really quick fly-through, so, hoping that you can tune into the other modules and webinars that we'll be doing, which go into a bit more detail about each of those aspects. So things like search and seizure, when a principal is investigating misconduct, things like special educational needs of students and discipline. We'll be doing another webinar on that. And I'm just keeping this open now for any questions, and I can see one question there. And the question is, can the school discipline a student when the action occurs school hours but they're in school uniform? I think there's a little bit of a grey area to that, but generally the consensus seems to be through policy documents and commentary by experts in the field that if they're in school uniform, the school's got an interest and jurisdiction over them because they're holding themselves out as representatives of the school, and obviously no one wants to see a student of a particular school defacing property or graffitiing, because obviously that reflects on the school. So that would be the argument, that the school does have jurisdiction over that student, even if it's outside of school hours and not even on school grounds, but they're in school uniform. It gets a lot more tricky when you're dealing with, say for instance, social media. Like if you've got a student that's bullying another student, it's not in school hours, it's not on school grounds, it's not even on school property, but it affects another student at the school. A lot of the commentary from professionals and even the Ministry of Education that's coming out recently says that, yeah, the school has an interest in disciplining that student, and they have jurisdiction because it affects school. And they would be breaching their obligations to provide a safe schooling environment if they didn't take action. So the reach of schools to discipline now is becoming wider and wider. It used to be really limited, so it used to be, only if the student is within a 10-metre line sight of the school. But now it's, if you're out in the public showing off your school uniform, or you're taking action which impacts and has a negative impact on the schooling environment, the school has an interest in it. So hopefully that answers the question, although it's probably gone a bit further than you asked. But yeah, it's a really interesting new area that a lot of law hasn't developed around, and we're still feeling our way through. But a lot of things will impact on that, like the new cyberbullying laws and things like that. Cool. So I'm just going to leave it there for a little bit longer just to see if there are any other questions from anyone. But as I said, just a little reminder for those that joined us a little bit late in the webinar, really appreciate if you're able to, if there's a number of you watching on one computer, just to put in your individual names so that we can record the total number of participants, just something we need to do for our reporting requirements. And we'd be much obliged if you could complete the SurveyMonkey survey, which we're going to put up as well. It gives us feedback on our webinars, and it's also part of our reporting requirements. And I just see there's another question. So if a kid is in a photo on social media in uniform, yeah, it's another really controversial area because there's a lot of cases coming out like this. And the commentary by the professionals that are advising Board of Trustees and some MOE commentary as well seems to suggest, yeah, the school has a legitimate interest in it if the student is in school uniform and it's on social media. Arguably, the property rights and the regulation of it would still belong to Facebook. But what the school then has an argument to say is that, look, we have a legitimate interest in someone who's holding themselves out as a student, as a school, on your website, and we think this is an offensive post and we'd like you to take it down. So, for instance, if there's a picture of a student in school uniform vandalising property, obviously the school's going to have an interest in it because it reflects on the school. Slightly different if you've got a student who isn't in school uniform, in normal clothing, there's a photo on their social media, but perhaps their profile identifies themselves as a student of a school. It's a little bit harder to make that connection, but there's still probably an argument that the school has legitimate interest in policing that and has jurisdiction. Certainly, we take a slightly more rights-based approach. So the schools boards and those that are advising the school boards would often say, hey, you've got wide-reaching jurisdiction as long as you've got a legitimate interest in it, even if it's outside of school grounds and outside of school hours. From a rights-based perspective, if we are advising a young person, we'd still also say, look, you do have a legitimate right to privacy. The United Nations Convention on the Rights of the Child, so if you remember we talked about that in Module 1, and also the Privacy Act. So you do have a legitimate right to privacy and freedom of expression under the Bill of Rights Act. However, what we do temper that against and what we do tell people that call us up and ask for advice is that if you choose to make your profile public and if you choose to publicise the fact that you are a student of a particular school, and then you publicise things which potentially could affect a safe environment at school or could bring the school into disrepute, the school may have a legitimate interest in it, and it may just be that although they may not be justified in meeting the threshold for gross misconduct or continual disobedience, they probably still have an interest in it and raising it with you as an issue, depending on what's happened on your social media post. But it is definitely a controversial and grey area, and the law is still developing in this area. So I'd probably say watch this space. We still haven't had a court case which has given us a clear answer either way, and the policies are really vague, but do give some guidance. So hopefully that answers the question a bit. Fantastic. I'm just going to leave it open for one more minute and see if anyone else has any other questions. As I said, we're very happy to take individual questions after the webinar as well. Feel free to email us at info@youthlaw.co.nz or contact us on the 0800 line, and we're open 10 to 4 Monday to Friday. Again, just a quick reminder, really love if people could please type in their individual names if there's more than one of you on one computer, and to finish with our SurveyMonkey survey. It will just take a few minutes, and it just helps us deliver a better webinar to you in the future.